If at the end of the trial, within the trial, the requisites for admissibility have not been proved, the confession may or must be excluded.
It can only be one of two things. My English is not Englishing right now, but Judge Ratha literally just contradicted himself by reading the law books, that as he likes to do, and the law book clearly says must be excluded. Let me play it one more time. Comment and let me know if I'm just grasping at straws.
If at the end of the trial, within the trial, the requisites for admissibility have not been proved, the confession may or must be excluded.
Obviously, there's nothing we can do about it at this point, but let me know, did you hear that contradiction or not? Let's continue on with what he had to say.
It cannot be admitted on the basis that other evidence may emerge during the course of the trial to justify its admission. Once a confession is admitted, its admission is provisional only in the sense that evidence may thereafter emerge which requires it to be excluded.
Okay, then he uncontradicts himself and says once a confession is admitted, it is admitted on provisional basis on the grounds that during the trial some more evidence can come up which can then take out the make the confession inadmissible. So this is a case of admissible, inadmissible. So okay, I see what he did here. He wanted to continue with the main trial. We are going back to the main trial on Monday. So the confession is admissible, but it's not 100% admissible forever. I guess that's what we have to hold on to as we continue with grasping at straws. Okay, he is a brilliant judge. I'm going to give him that. He found that loophole and he used it so the trial can continue. But I wonder how Monday is going to go with the defense, because the defense needed time to debrief on hearing that verdict, the ruling, and then they came back to say, okay, let's do the main trial on Monday. So they must have an ace up their sleeve. I don't know. What are your thoughts? Comment down below. And don't forget, have you liked this video yet? We absolutely enjoy it when you like the video, and even more when you comment down below. Remember, this is an open space. My house rules is simply, let's keep it respectful. You can comment in any language you like, whatever you're comfortable with. But one thing I do ask is for the respectful nature, especially when you're replying to somebody else's comments. I've seen some name calling going on. This is a very, very, very polarized, sensitive trial, I'm thinking, and it can only get worse from here on. So just keep that in mind. Let's continue breaking down rather to his contradictions and non-contradictions.
Right, that is the law. So it mustn't be argued that this judge didn't consider the evidence regarding coercion. In other words, the synopsis of the encapsulation of the evidence, the salient features are this: that when the state intended to bring into play by introducing the so-called alleged confessions or statements of accused number 1 and 2, and the pointing out by accused number 2, the defense objected. And the principal objection was that, 1, they did not make statements. They did not make confessions. They were told to sign documents which were fully completed, and they were told sign here, sign there, initial here, initial there. That was the initial defense.
One thing about Ratha, he's that guy who's going to lead you on and make you think, okay, I've made it in life, only to find out he is going to contradict what he's already saying. So listen to him saying that, hey, the defense argued and said, hey, Balo, you can't bring in those statements. Those statements were not made freely and fairly, and that the statements were written. They were pre-written, and these guys had to sign. You know what? For me, it's really, they were pre-written in English. How did Mzansi write the statement in English? I think that's what the defense should have argued and stuck with it. More than I get now in hindsight than talking about they went driving, they went on a tour, they tortured him, they did this and this. Had they focused on the language that the statement is produced in and how it became written in that form, then I think the defense would have won in terms of showing that the Mzansi didn't do the statement. But let's continue listening to Ratha as he continues to contradict himself.
The second defense is that they were assaulted, tortured severely, as Mr. Mgomezulu put it, severely tortured, tubed, electrocuted, kicked, in order to elicit their signatures on the documents. In other words, these accused before court, their evidence is they don't know the contents of the confessions. They don't know. They were never read to them. And if you go further, accused number 1, for instance, says when he went to sign the confession or statements before Maboto, I think, Maboto never even sat down. When Maboto came, they were assaulting him. All that group of policemen. And Maboto then called him aside and said, hey, you know what? Why don't you sign these documents? These guys are going to injure you. And then, to save his life, accused number 1 says he signed. No discussion with Maboto in an office sitting down, according to accused number 1. Accused number 2 also says when he went to sign the alleged confession or statement before Mrs. Kronje, all he said when he got in, even before Mrs. Kronje could introduce herself as a magistrate, he came in and told Mrs. Matlaping, the interpreter, that, may you tell the lady, please, that 6 weeks I haven't had a bath, from the 16th of June, I think. And also that I want to speak to my daughter, I want to speak to my partner or parents. And that was it. And he sat down and looked at the ground. And Mrs. Kronje, what he did was, he was busy with his computer. She never asked him anything. All she was interested in was the computer, and then she would get out and gossip with a fellow magistrate or fellow white lady and come back. Mokhono was going in and out, consulting with Mrs. Kronje. Nothing was discussed between accused number 2 and Mrs. Kronje, except, as I said, that I haven't had a bath and I want to speak to my daughter and my partner. Nothing. The same applies for Rapudu. Accused number 2 says, no discussion with Rapudu, nothing. He was just beaten up and told to sign. So in the main, that is the salient aspects of the evidence relating to the trial within a trial. It's obvious that Jeninda, Maholerwa, and others gave evidence. But what I want us to understand is that this court, after careful analysis of the evidence adduced by the state, and after careful analysis of the cross-examination interposed by the defense against the evidence adduced by the state, and after careful analysis of the rebuttal evidence of accused number 1 and 2 and the cross-examination interposed by the state, and after careful analysis of the heads of argument by all the parties concerned and the verbal submissions made by all the counsels in this court, I have dealt, not like this magistrate did,
And there we have it, another contradiction. He read, remember at the beginning, he's reading from that book and he's telling us why the evidence is going to be, remember, he led us to believe that he was going to rule from reading that book that the evidence was going to be inadmissible. And then at the end of it, he says, unlike this judge here, and then he goes on to say admissible. So why did he waste our time listening to all those previous cases? Why? What was the reason? Oh my goodness. What do you think of that contradiction? Let me know in the comment section down below. Let's continue the conversation down below. If you haven't already, please make sure you like this video, subscribe to this channel, because we're coming back with more. We have Thabo Bester later on today. Are you going to watch Thabo Bester, tracking Thabo Bester on Showmax? Thanks so much for watching. Catch you on our next upload.
I've dealt with all the evidence relating to whether the said alleged confessions were made freely and voluntarily in the sound and sober senses of the deponents without any force or coercion. I've dealt with all that, and I've also dealt with the other primary defense by the accused, that all the accused were not apprised of their constitutional rights, meaning section 35(5) of their rights. They were never apprised according to that. And this court even also interrogated that. And as we all know, Section 35 encapsulates the concept that if any evidence is acquired through the infringement of the Bill of Rights, that evidence should not be admitted into the record of the proceedings relating to Section 17 and Section 18, even Section 19 of the Criminal Procedure Act. Right. Consequently, after going through all that evidence carefully, this court has reached the following conclusion. One, it rules that the confession made by accused number 1 was made freely and voluntarily without any coercion when accused number 1 was in his firm, sound, and sober senses. 2, the confession made by accused number 2 in respect of the said confession being taken by Mrs. Ronje, the magistrate, the court rules that it was made freely and voluntarily without any coercion when accused number 2 was in his full and sober senses. And also the confession made before Colonel Rapudi was also made by accused number 1, 2. Freely and voluntarily without any coercion when he was in his sound and sober senses. And also the pointing outs made by accused number 2 before Colonel Khadebe were also made freely and voluntarily without any coercion when accused number 2 was in his full and sober senses. Okay, that is the ruling.